Today we're going to talk about legislation, case law, and how it all intersects with the Jonathan Majors case. As of today, which is February 16th, 2024, we are in the post-conviction phase of the Jonathan Majors trial. It is still an active case as sentencing has not yet occurred, and the defense team has filed several motions before that will take place. And one part of that motion, will be the focus of what we're going to go over right here. Now, there's been a ton of buzz about, well, why didn't Jonathan Majors just make a self-defense justification argument? Well, this is going to break that down for you. We're going to talk about how justification is a defense according to New York state law. We're going to look at case law that defines the reading, the instruction of the justification charge to the jury when any evidence at all could point to self-defense being a justification, a reasonable justification. That justification charge being read to the jury would be a matter of simple justice according to case law, binding case law from New York State, from other New York cases. And by the end of this, I think you'll see why the defense is going to be able to make a compelling argument that the assertion of self-defense as a trial strategy was not needed, and a request for a justification charge, which is the instruction being read to the jury, was not needed to have been made by the defense. The court should have made one anyway. Keep in mind that what we're going to look at today, even though it's in this post-conviction pre-sentencing phase, the same argument could be raised on appeal if necessary. For key context, the trial judge, Judge Gaffey, will be the one looking at this motion to set aside the verdict, so you can make your own guess as you will, as you wish, as to whether or not this will go anywhere within the trial court. But keep in mind, you could see the same argument raised on appeal. If you'd like to check out the text document that Jonathan Majors' defense filed, I'll put a link to that in the description. It's a 47-page PDF. If you want to just look at a reading with a live chat present there, you can go. I'll link to this video where we all talked about it together. And just so you know, 3 grounds were raised on this motion to set aside the verdict. This video is going to focus on the justification charge and legislation and case law supporting that argument here. I've seen a lot of people, and understandably so, but maybe not applicably so, argue that, hey, the defense during trial should have asserted an affirmative defense. They should have made the argument from opening to closing that Jonathan Majors was just using self-defense in defending himself against Grace Jabari on the night of March 25th, 2023. But if the defense had done that during the course of trial, it would have shifted the burden a little bit. It's the prosecution's burden to prove their case beyond a reasonable doubt. But once an affirmative self-defense justification is asserted, the defense actually bears the burden through preponderance of the evidence to convince the jury that the underlying act was justified through self-defense. Additionally, it would also be admitting that the underlying acts, which in this case we have the injury that took place in the car to the finger, and then the injury that took place behind the ear, it would be confirming, it would be affirmative that, hey, the prosecution's saying that those injuries occurred at this exact moment of time by this mechanism of injury. And by asserting an affirmative defense with a self-defense justification, you'd be concluding that the injuries happened by that mechanism during that course of time. So there's been a lot of criticism about the defense trial strategy here, and I hope by the end of this video you have a better understanding of why we didn't see that as an active trial strategy. And just to drive that point home with what I'm getting at the burden shifting and why it's so important, I want to highlight Andrew Branca with the law of self-defense, because this is actually where I started to grasp this concept. When it comes to New York State says when a defense other than an affirmative defense defined by statute is raised at a trial, the people, the prosecution, the state, have the burden of disproving such defense beyond a reasonable doubt. But look at item 2. When a defense declared by statute to be an affirmative defense is raised at a trial, the defendant has the burden of establishing such defense by a preponderance of the evidence. And again, just to drive home one more time, asserting an affirmative defense during the course of trial would have been saying that, yes, the injuries did in fact occur as the prosecution is claiming they occurred and when they claim they occurred. Now, before we get into case law, let's go over some basic concepts. This may be some stuff that you guys are familiar with, but if you're not, I think this will give you a good framework for understanding what follows from here. And that means we want to understand case law, precedent, stare decisis. Now, when we're looking at things like what we just looked at, things like New York Section 35, justification of defense, and we'll get into all of this. This is legislation. This is stuff that's rules codified into law. But case law and precedent can be a little different. Case law and precedent are related concepts in the common law system, which is based on the principle of stare decisis, which is Latin for to stand by things decided. Case law, and you probably hear this term referenced a lot, is law that's based on precedent. It relates to things judges decided in other cases, rather than law based on constitution, statutes, rules, anything that's codified by the legislation. And I think it's important that with case law, topic and subject matter, there's an affinity there. You want to look at case law And it's good to understand that case law refers to the collection of precedents and authority set by previous judicial decisions on a particular issue or topic. Precedent refers to a court decision that is considered as authority for deciding subsequent cases. And there's a similarity element there, right? So if something is almost an identical situation, it's good to look at precedent on something else that was from a similar situation. And going back to stare decisis, or again, to stand by things decided, precedent ends up being kind of incorporated, and courts will continue to apply that law in the same manner to cases with similar facts in the future. For the sake of simplicity, there's two different types of precedent that I think are good to know for our conversation today. Binding precedent, that's precedent that a court must abide by. So if a court is adjudicating a case, that means they're making judicial decisions about a case. This precedent is something that they are bound to follow. A great example is when a lower court is bound by the decision of a higher court in the same jurisdiction. It doesn't matter if the judge in the lower court disagrees with the reasoning or outcome of that decision. Then there's also persuasive precedent. So that's precedent that a court may, but isn't required to, rely on in deciding a case. This often involves decisions from courts in neighboring jurisdictions or something written in an opinion, even a dissenting opinion that wasn't part of the direct decision in, a higher level appeal case. Now, pretty much everything that we're looking at today is going to be binding precedent. It happened in a New York State jurisdiction. It has parallel legal questions or similar circumstances of the initial trial case itself. And what that essentially means is what Priya, Seth, and the Chaudhry law firm are arguing in the motion to set aside the verdict, and will likely argue the same things in further appeals, is that, hey, what happened at trial, what happened at Jonathan Majors' trial wasn't right. And there's already binding precedent. There's a set of case law that demonstrates that something should have been done that was not done at trial, i.e., reading of this justification charge in jury instructions. That wasn't done at trial, and justice was denied, and then they lay out the case law, the relevant case law, that demonstrates that precedent is already here for this. The legal question has already been answered by New York State courts, and this trial court failed to follow. So, let's get into the legislation. Justification is a defense. According to Section 35, and this is from New York State, justification, a defense. In any prosecution for an offense, justification, as defined in Sections 3505 through 3530, is a defense. More specifically is 3525, where we find out that justification, use of physical force to prevent or terminate larceny or criminal mischief in defense, is justified. That's a specific statute. You've seen a ton of people floating around as it relates to this specific case. You can use physical force to prevent or terminate larceny or criminal mischief. Person may use physical force, other than deadly physical force, upon another person when and to the extent that he or she reasonably believes such to be necessary to prevent or terminate what he or she reasonably believes to be the commission or attempted commission by such person of larceny or of criminal mischief with respect to property other than premises. That's why it's also really important to remember that Jonathan Majors' accuser, Grace Jabari, was charged not just with domestic assault, but with criminal mischief. 2 different NYPD detectives from 2 different precincts found probable cause for both of these charges. So if they felt like there's enough to believe that criminal mischief is occurring, it would make sense then to conclude that Jonathan Majors reasonably believed there was a commission or attempted commission by such other person of larceny or of criminal mischief with respect to property. The last piece of legislation I want to look at before we get into case law is Section 25. We're going to talk about that burden of proof again. Now, I know my little presentation text is small here, but bear with me. Justification can apply whether the defense is affirmative or not. And we've already discussed the specific piece of legislation that makes this so. Again, when it's just a defense, the people have the burden of disproving such defense beyond a reasonable doubt. But when a defense is declared by statute to be an affirmative defense, the defendant has the burden of establishing such defense by preponderance of the evidence. I think that's just such an important point to drive home. Now, the rest of this video, we are going to look at case law, most of which was specifically cited by the Chaudhry team in the motion to set aside the verdict, and also some general other precedent that relates from New York State courts. The case law on this topic makes it clear that the people, the state, the prosecution, have the burden of disproving such defense, one that is not affirmative, beyond a reasonable doubt, and that the jury should be read the justification charge, even if the possibility of defense is not injected by the defendant at trial. I'm going to say that again. Case law makes it clear that the people have the burden of disproving defense, one that is not affirmative beyond a reasonable doubt, and that the jury should be read, no discretion, should be read, the justification charge, even if the possibility of defense is not injected by the defendant, and even if the defendant does not explicitly request this be read to the jury. And again, we're going to get into this case law, but remember, there were 3 different arguments raised in this motion to set aside the verdict. One of them was Mr. Major's reckless assault convictions should be set aside because the jury was improperly charged. And one of the grounds for that argument is that the court should not have submitted both counts of assault to the jury because they are inconsistent. The court erred by submitting the reckless assault count to the jury without also submitting a justification charge. We're going to focus in on this, and there's so much case law backing it right from New York State. It's not from other jurisdictions. Let's get into it. First, we're going to look at People v. Steele. I've highlighted key parts, and I'll link to a document that has all my notes that I'm using to make this video in the description. It should contain my highlights. That way you can see the relevant parts that apply to the argument that Jonathan Major's defense team is making. Like, hey, this is the precedent that matters from this existing case law. I've highlighted those parts for you. You should be able to see them if you open them on your own. But most of them are short, so I want to read to you the full context. And what I think is interesting is some of these cases involve a lot more definitive actions and a lot more egregious actions. But the appeals court, further up the line, when asked to evaluate what happened at the trial court level, in these cases, they're finding, hey, the defendant was denied his right to a fair trial, burden of proof, something went wrong with it, you didn't read this justification charge, new trial. So let's get into this first one. It's People v. Steele. This was decided on May 28th, 1970. On November 25th, 1967, Hassel Thompson was visiting at 1077 Tiffany Street in the Bronx. As he was leaving the building, he met defendant and her brother, during which encounter defendant drew a gun and ordered him from the premises. Later that evening, Thompson returned to the area and again encountered the Steeles. He became embroiled with defendant's brother and, according to all of the prosecution witnesses, was shot twice in the leg by defendant. Thompson claimed that a knife appeared in Steele's hand and that during the fight, he was shot by defendant and then stabbed by her brother. So remember, Steele is Miss Steele. Miss Steele is the defendant here. Other prosecution witnesses, Jose Santiago and Hector Melendez, however, testified that Thompson had the knife, but that Steele wrested it from him. According to their story, Thompson was stabbed by defendant's brother and then shot by a defendant. So Miss Steele does the shooting, but Thompson had the knife first. Defendant testified that she was not in the area when the shooting occurred and did not shoot Thompson. During this summation, defense counsel attempted to argue in the alternative that if Ida Steele did the shooting, it was in defense of her brother. A prosecution objection was sustained. In turn, the prosecutor in his summation stated, "I'm going to concede one thing to you very quickly. Hank Thompson lied to you in this case. My witness, the complaining witness, the man who was injured, lied to you. I think the evidence shows that this is his knife. I think the evidence will show that, and that he went home and probably got this weapon, this knife, and I think the evidence further shows that he came back. I think he was the initial aggressor against Thomas Steele. He missed with his lunge." Defense counsel requested that the court charge justification as a defense under Section 3515 of the revised penal law. The request is predicated upon that testimony that Thompson had the knife and that the jury might find that the defendant was acting in defense of a third person. The court incorrectly refused to so charge. Justification is a defense, as opposed to an affirmative defense, and the people have the burden of disproving such defense beyond a reasonable doubt. Of course, justification as an affirmative element need not be disproved in every case. Ordinarily, the possibility of the defense would not appear until injected by the defendant. But here, the prosecution's case, viewed separately, warrants the requested charge. The people's eyewitness, so the witness. So what we're getting to here is why this is so applicable to the Jonathan Majors case, not just because it relates to the legal question of when a reading of the justification charge to the jury, but also how the element of defense becomes part of the record. So here, the possibility of the defense isn't injected by the defense team. It was injected by the record. The people's eyewitnesses testified that Thompson possessed the knife, and the assistant district attorney, with commendable candor, frankly admitted that the complaining witness was the initial aggressor. What similarity do we have from Grace Jabari's testimony? And also the other state witness, Naveed Sarwar. If we remember the testimony of Grace Jabari, she says she was the initial aggressor. We also have that repeated in what she said to the police on that morning of March 25th. The other witness, the driver, Naveed Sarwar, said he was doing nothing, she was doing everything. It sounded like she hit him first. He just wanted to get out, get rid of her, get away. And so here we're talking about the possibility of defense doesn't need to be inserted by the defense. People's eyewitnesses were enough to put it on the record that there was a possibility the defendant acted in a defense and a justification charge should have been read. Let's keep reading. The people's eyewitnesses testified that Thompson possessed the knife, and the assistant district attorney, with commendable candor, frankly, admitted that the complaining witness was the initial aggressor. Consequently, a jury could find that defendant reasonably believed that Thompson was using or about to use unlawful deadly physical force. Now remember, they were looking at 3515, we're looking at 3525, which doesn't justify deadly physical force. It justifies physical force other than deadly physical force. At the time she shot him. In determining the requirements of the court's charge to the jury, defendant is entitled to the most favorable view of the record. So it doesn't matter if one could argue, hey, there's an alternative explanation here where we don't actually believe this. We agree that, Steele always had the knife. Steele never had to get that knife away from Thomas. There was no perceived threat. Doesn't matter if that's a possibility at all. Because in determining the requirements of the court's charge to the jury, defendant is entitled to, always, the most favorable view of the record when it comes to should this justification charge be read. And there's plenty of well-established case law on this in New York State. Although we are not dealing here with the typical charge-down situation, the rationale of the cited decisions is equally applicable to matters of defense. Finally, the question remains whether the alibi defense precludes the requested charge. We have recognized that the jury may believe portions of both the defense and prosecution evidence. Since a jury might disbelieve the alibi and still find, on the prosecution's evidence, that defendant acted justifiably, the prosecution claim of inconsistent defenses is not a bar to the charge requested. On this record, the prosecution's witnesses created the opportunity for the defense. So they're saying, defense does not need to assert this. We do not need to get up here as the defense counsel during trial and assert an affirmative defense just to be able to have this justification charge read, and that means the prosecution still bears the burden of proof beyond a reasonable doubt to show that the defendant was not justified. So the appeals court on this issue ends up agreeing that the instruction should have been given, and they reversed the decision and a new trial was ordered. So that, my friends, is People v. Steele. Over 194 cases have cited this opinion. Next, we're going to look at People v. Padgett. This case is super important because it establishes precedent on recklessness. What we're going to see in this decision is that the Court of Appeals rejects the contention that the justification defense is available only where conduct is admittedly intentional. And they're going to cite other precedent holding that justification defense applies even when an act is committed inadvertently. So let's talk about Padgett. Let's see what happened in a trial and why the Court of Appeals is making the decision they make here to reverse. Defendant Padgett was convicted on one count of criminal mischief in the 4th degree. The charge, along with several assault charges, arose out of a barroom incident during which defendant broke the glass in an emergency fire exit door. Defendant's conviction was affirmed by the appellate term. That means a different appeals court. The issue presented is whether defendant was entitled to a charge that the jury could find that his conduct was justified and therefore not criminal. The owner of the bar in which the incident occurred testified that defendant and his two companions engaged in boisterous conduct, and that eventually, and as the result of that conduct, the alarm on the emergency exit door of the bar was activated. When the owner reset the alarm, defendant laughed and triggered the alarm again. When the owner asked defendant what he was doing, defendant struck the door with his fist, shattering the glass. The charge of criminal mischief is based upon the damage to the door. After the door was broken, the owner went to call the police. As he attempted this, defendant and his companions began to leave by the front door. The owner went after them, asking who was going to pay for the broken glass in the door. An altercation ensued involving the owner, his father, also a part owner, defendant, and his friends, out of which the 4 assault counts against defendant arose. The bartender, 2 patrons, and the owner's father all testified in a manner corroborating the owner's version of the event. Defendant's version is quite different. He testified that he and his friends were telling jokes and having a good time at the bar when they were informed by the bartender that their presence was no longer welcome. The trio attempted to leave by what turned out to be the emergency exit door. The alarm went off, causing the bar owner to verbally abuse the defendant. After he reset the alarm, the owner threatened defendant, who became frightened. Defendant, believing the owner was about to hit him, tried to exit through the emergency door. So basically, that's why it was going off twice. He pushed the frame of the door hard and the glass shattered, but he stated that he neither pushed on nor punched the glass. An altercation ensued, joined in by others at the bar. Defendant requested that the court charge the jury of the defense of justification as being applicable to the 4 assault charges as well as the criminal mischief charge. The trial court instructed the jury that justification was the defense to the assault charges, but refused such an instruction with regard to the charge of criminal mischief. The court stated that the defense of justification is not applicable to a charge of criminal mischief. Defendant was acquitted of the 4 assault charges, but convicted of criminal mischief. So the jury in this trial, at the trial level, while they're deliberating, they have 5 counts to consider, 5 charges to consider. And 4 of them, which happen to be the assault charges, all have this justification charge read to them. But then they get to the criminal mischief charge where there's no justification charge there. So imagine you're a juror sitting in the jury room and you're like, well, we think his actions were all justified. But according to these instructions, the justification only matters when we consider these 4 charges. When we consider this other charge, there's no justification for us to consider for it. So, do you get where I'm going with that? An appeal to the appellate term resulted in affirmance. So the first court that they take this to, first level of appeal, the appeals court affirms the verdict. The majority held that although the justification defense might be applicable to a charge of criminal mischief, there was no reasonable view of the evidence in this case that would support it. Accordingly, the majority held that the failure to submit the question to the jury was not error. One justice dissented, stating that, in his view, defendant's testimony was sufficient to support the defense, and that the defendant was therefore entitled to the charge of justification. We agree with this dissent and therefore reverse. Initially, we note the well-settled principle that, and this is we're going to get People v. Steele cited here, among other cases. We're going to see this precedent come back up. It's well established. In considering whether the trial court's charge to the jury was adequate, the record must be considered most favorably to the defendant. You can see People v. Steele as the second cited here. If, taking that view of the record, the evidence supports the defense of justification, the trial court should instruct the jury as to the defense and must when so requested. Thus, if on any reasonable view of the defense, the fact finder might have decided, the fact finder is the jury, so if on any reasonable view of the evidence, the fact finder might have decided that defendant's actions were justified, the failure to charge the defense constitutes reversible error. So, again, most favorable to the defendant is how we determine if this justification charge should be instructed to the jury. And remember, we have one thing here, and even if it's not the thing you think is the most plausible, the fact that it's reasonable means the defense says, hey, I didn't really intentionally do this. I was just trying to get out the door and the glass breaks. It's not like I intentionally pushed on the glass. That's reasonable, right? Whether that's true in the moment. It's reasonable, and the justification thus should have been charged to the jury, the appeals court has found. So we're going to go over to this other highlighted paragraph here. In the present case, defendant claimed he was trying to avoid what he believed was an attack by the bar owner. He pushed hard against the emergency exit door, hard enough apparently to break the glass, in order to retreat from what he described as unprovoked aggression. The justification defense seems peculiarly appropriate to a situation such as this, where defendant inflicts damage to a property in his attempt to avoid physical injury to himself. The people argue, however, that defendant was not entitled to the justification charge because his testimony indicated not that defendant caused property damage to avoid personal injury, but that he never intended to cause property damage. So, during trial, the state was like, no, you're not entitled to this justification charge because you didn't assert that you did this out of defense to avoid injury. You simply said you didn't mean to cause property damage. Thus, property damage is caused recklessly or inadvertently. And that's not enough for us to charge this justification instruction, even though you're asking for it. Well, now we have this precedent set by this appeals court that says, we disagree. Here's why we disagree with how the prosecution made that argument during trial. The people would limit the availability of the justification defense to cases in which the conduct is admitted to have been intentional, but in avoidance of a greater injury. The cases on point, particularly Huntley, so they're citing one of these cases they've referenced previously, indicate that the people have tendered a much too narrow interpretation of the circumstances under which this doctrine may be applicable. Here, in this active case, as in Huntley, an aspect of the defendant's testimony is inconsistent with the defense. In that case, Huntley never admitted that he intentionally stabbed the victim, just as the present defendant never admitted that he intentionally broke the glass. Indeed, it appears well settled that this type of inconsistency should not deprive defendant of the requested charge. And here, where they're citing People v. Steele again, they're citing this here, that the record must be considered most favorably to the defendant, and that in taking that view of the record, the evidence supports the defense of justification. The trial court should instruct the jury as to defense and must do so when instructed. So if the evidence is in the record that defense was a possibility, and we also have to look at the record most favorably in a way that's considered most favorably to the defendant, then the justification should be instructed to the jury. So, defendant's explanation indicates that he engaged in conduct in avoidance of the perceived attack. That conduct forms the basis for a charge of criminal mischief. The fact that defendant never admitted that he intended to cause the resulting property damage should not disentitle him to a charge that his conduct might not have been criminal under the circumstances. So, they reverse this decision, and a new trial was ordered. So again, our takeaway there is the justification defense isn't only available when the defense comes out and says, yep, I did that intentionally. It should be read even if an act is committed inadvertently. And the defense does not need to come out and say, hey, we admit that we caused this injury, but we did it inadvertently. It just has to be a possibility on the record, and that record needs to be viewed most favorably in the light of the defendant. They get the biggest benefit of the doubt. Is it reasonable from the record, any of the witnesses that testified at this trial, is it reasonable to believe that even if they caused some type of injury inadvertently, would it be reasonable to find, based on testimony from witnesses in the trial or anything else on the record at trial, that whatever the defendant did, intentionally or inadvertently, doesn't matter? Is it a reasonable possibility that it could have been justified? Because if so, no matter whether it's asked for or not, no matter whether the charge is intentional or reckless, the court must read the justification charge, the relevant justification charge. So that's what we're getting out of People v. Padgett. Now we're going to get to People v. Kraft, which was also cited, and it's going to, underscore once again that the jury should have been instructed on justification as a defense, even if the defense doesn't request the charge be read. Because it doesn't matter if it's requested, if the evidence in the record at trial warrants it. And we're going to get to the highlights here, but again, if you want to read the whole, it's a 2-page opinion, you can go and read that. It'll be linked in my document in the description. But although neither requested prior to the trial court's charge, nor accepted to thereafter, defendant maintains, and in the interest of justice, we agree, that with respect to the attempted assault charge, the jury should have been instructed on the defense of justification, viewing the record most favorably to the accused, as we must when the adequacy of the charge is the issue. There is substantial evidence supportive of this defense. Accordingly, the jury should have been charged on the elements of justification as a defense. So even the trial defense team at trial didn't request it, and they didn't take exception after, previewing the jury instructions before they'd be submitted to the jury. They didn't take exception. They didn't try to argue, hey, wait, we need to include this other thing. You guys missed this opportunity to include it. It does not matter, because as a matter of simple justice, this defendant had the right to have this justification charge read as part of jury instructions, and it was the court's error to not make sure that happened. And what's most interesting about this case is where defense becomes a possibility, the appeals court actually argues it's so vague that the jury would have missed it. And thus, it makes even more sense than ordinarily that it must have been instructed. You were supposed to instruct this. So it goes on. Indeed, had defendant requested such a charge, the court would have been obligated to give it, since the only judicial guidance provided on this issue consisted of the trial court's comment that, quote, defendant contends that he did not attempt to strike the correction officer, that the correction officer hit him first against the wall, and that he was not aware of the shank in his cell or how it got there. The appeals court is looking at this little piece on the record from just the judge. It wasn't argued by a witness. It wasn't argued in opening or closing statements from either side. The appeals court is saying, hey, with this bit from the trial court's comment, this could hardly have alerted even the most perspicacious jury to the defendant's contention that he was acting in self-defense against an unprovoked attack. In short, despite defendant's failure to request a justification charge, the evidence warranted such a charge. So this appeals court majority opinion says we're reversing the judgment and it's going back for a new trial. So if you get where I'm getting at, they're citing this case law and they're pretty much saying, hey, even if there was even one tiny slim reason to believe that there was a reasonable possibility that the defendant was acting in defense, even if it's not coming from witness testimony, even if it's not a theory being asserted by the defense at trial, the court erred in not reading this justification charge to the jury. And if there's anything in the record, and here it was just this little teeny bit from a judge's comment, if there's any bit in the record that could suggest the possibility of defense, because we have to view this most favorably to the defendant, it's got to be read. This justification charge has to be read whether or not the defendant requests it. Because in this case, the defendant never requested it. But wait, there's more. Because we're going to get to People v. Sarita. And this one's short, so we're just going to read this. And what we're going to get out of this is that where evidence-supported charge on the totality of the facts and circumstances, the trial court's failure to charge the jury on the defense of justification constitutes reversible error, even if defense counsel doesn't request this charge be read. So do you get where I'm getting at? There's a collection of these precedent. There's case law on this idea that this justification charge should have been read to the jury, and it was not in Jonathan Major's trial. The appeal by defendant from a judgment of the Supreme Court, Queens County, rendered February 6, 1979, convicting him of reckless endangerment in the second degree and menacing, upon a jury verdict and imposing sentence. Judgment is reversed on the law and as a matter of discretion in the interest of justice and a new trial ordered. At about 12:30 a.m. on July 21, 1978, while driving an automobile belonging to one of his passengers, defendant stopped on Utopia Parkway and waited for a change of light at the corner of Northern Boulevard. Edward Harris, a police officer riding home on a motorcycle and wearing civilian clothes, pulled up on defendant's left. Defendant leaned out his window and derided Harris's motorcycle, not knowing at the time that Harris was a police officer. When defendant turned right onto Northern Boulevard, Harris followed from the left lane, moving ahead of defendant's vehicle. When Harris was 50 to 100 feet in front of defendant's vehicle, he dismounted his motorcycle and approached defendant's vehicle, which had pulled toward the curb. Harris explained at trial that his purpose was to take down the license plate number of defendant's car so he could report defendant's earlier reckless driving. The defendant claims that when he had made the remark about the motorcycle, Harris threatened to harm him and was then attempting to make good on his threat. In any event, defendant, seeing Harris take a few steps towards his car, rapidly accelerated into the traffic on Northern Boulevard. Harris claims that the car would have hit him had he not quickly jumped to the curb, but defense witnesses said the car did not go near Harris and that the defendant was merely trying to get away from him. Harris then remounted his motorcycle and followed defendant's vehicle east on Northern Boulevard, then north on a side street after turning left off of Northern Boulevard. Defendant's vehicle stopped soon after turning. Harris stopped some distance behind, and another vehicle with friends of defendant inside stopped behind the motorcycle. Persons exited both cars and surrounded Harris. When defendant was 20 to 30 feet away from Harris, he removed a studded belt from his pants, wrapped it tightly around his hand, and presented the wrapped fist to Harris, still seated in his motorcycle. Defendant asked Harris what he wanted. Harris identified himself as a police officer and replied that he wanted to take down the license plate number of the car defendant was driving, and that he had done so. Defendant put his belt back on his pants, never having come closer than 10 feet to Harris. The occupants returned to their cars and proceeded to their destination, a friend's house, followed by Harris, who had called for assistance. Defendant was later arrested leaving the house. Defendant was convicted for reckless endangerment in the second degree arising out of the incident involving defendant's alleged attempt to hit Harris with the car, and for menacing arising out of the wrapped fist incident. Although defendant's other contentions are without merit, so the other things that they're arguing on appeal, no merit, there are two which warrant reversal of his conviction and a new trial, so we're agreeing with two issues raised on appeal here. As to the reckless endangerment charge, defendant's claim that he took the actions he did for the protection of himself and his passengers warranted a charge on justification despite defense failure to request it. On the totality of facts and circumstances described, the failure to charge the jury on the defense of justification constituted reversible error. So for this reason, they give two, but for this reason, they're finding this warrants reversal. So we're reversing the court's decision, the trial court's decision, and new trial. So again, this is another reckless, no intent, and based on the totality of facts and circumstances, the jury should have been charged with this justification instruction, and they were not. So the court erred, and it's reversible error, a new trial. Then we've got People v. Moore, which is going back to 2009, and this is the example I want to give of something that's more persuasive. So this is actually going to come from dissenting opinion. Again, a dissenting opinion is not binding precedent or case law, but it's just persuasive and could be used and adopted as law in future court cases or in legislation. A dissenting judge may write a dissenting opinion to get clarification on the majority from their own appeal bench or to affect future judgment about similar situations in future cases. And there's actually a quote, if we go back to Chief Justice Charles Hughes, this is back in 1936. He says that, quote, "A dissent in a court of last resort is an appeal to the intelligence of a future day." I think people that are really interested in appellate arguments really like dissenting opinions because they really do become adopted laws in future cases. Some famous dissenting opinions are from Dred Scott and Plessy v. Ferguson that end up being adopted later on, even though at the time the majority court didn't agree with the dissenting opinion that now today is actually precedent or law, even codified into legislation. Now, you can read all this. This is actually one of the longer ones. I'm sorry, it's like 7 pages. But in short, it's a couple, guy and a girl. They get into a heated argument. According to the complaint, the girlfriend says that the defendant, the boyfriend, attempted to drive away in her truck after pushing her out of the car. But she was still hanging on to the car and was being dragged while he was driving. So that's the situation that's going on with People v. Moore. And the issue, as alleged during trial, is that the defendant drove the truck for a significant distance with the complainant hanging on outside, swerved in an apparent attempt to throw her off, sideswiped a parked automobile, and ultimately jumped a curb and crashed into a tree and a fence. The defendant then fled the scene on foot. The complainant was thrown from the truck and suffered numerous injuries, including a fractured hip. So in the motion to set aside the verdict, the Chaudhry law firm wants to reference this one part of the dissenting opinion, where it says here, "In my view, although the majority's interpretation of the defendant's testimony as suggesting that the complainant caused her own injuries may also be reasonable, it is nevertheless improper because it fails to view the evidence in the light most favorable to the defendant, as we are required." And then we see People v. Hill referenced. In some, viewed in the light most favorable to the defendant, there's People v. Padgett again. The record demonstrates the Supreme Court committed reversible error in failing to, sua sponte, instruct the jury on the defense of justification, since a reasonable view of the evidence would have permitted the jury to conclude that the defendant's conduct was justified. Now, where this is stemming from is that at trial, the defendant went into testimony about a third person, that someone was coming up and trying to rob the vehicle, and that's when he happened to be driving away, and didn't notice at the time that it was the girlfriend clinging onto the vehicle. So, whether that sounds like an excuse or not, the jury is the finder of fact, and since there's something on the record, when the court's deciding whether or not to include this justification charge reading, it doesn't matter if the court thinks that it's an improbable or impossible scenario. The fact that it was even existing on the record, and it's something that could have explained a defense justification, the charge should have been read to the jury. And in this particular case where there was an issue is the charge was actually read on one. The justification charge was read for one of the charges, but not another, and he was found guilty of the one where the charge wasn't read and found not guilty on the charge where it was read. So the dissenting opinion goes on here to say that further, considered in the context of the jury's acquittal on the two other charges, assault in the first degree and attempted robbery in the first degree, it cannot be said with certainty that the jury would have rejected a justification defense with respect to the charge of assault in the second degree. Now, People v. Moore comes up for several reasons in the motion to set aside the verdict, because it was a case that the court relied on, Judge Gaffey relied on, while making his argument in response, his ruling in response to requests to change the charges on December 13th. And it's a separate argument than the pieces that we're looking at for the purpose here. And maybe I'll do a separate video on that. Let me know if you want me to. But what's important about the dissenting opinion here is that as it relates to the court failing to read this justification charge to the jury, Jonathan Major's counsel is arguing, and although the Court of Appeals in Padgett highlighted that the instruction is mandatory when so requested, and should be provided even if not requested, both prior and subsequent appellate decisions leave no doubt that even when a defendant failed to request a justification charge, a reversal and a new trial is necessary, if in fact the evidence warranted such a charge, and the trial court failed to provide it sua sponte. So they cite that down here. You'll see People v. Moore. They cite the paragraphs that we highlighted. Viewed in the light most favorable to the defendant, the record demonstrates that the Supreme Court committed reversible error in failing to, sua sponte, instruct the jury on the defense of justification, since a reasonable view of the evidence would have permitted the jury to conclude that the defendant's conduct was justified. So the reason I think we have that intentional footnote about People v. Moore isn't because there isn't precedent existing on this idea that, hey, Viewing in the light most favorable to the defendant, the record demonstrates that there could have been a reasonable defense, and thus the jury should have been read that justification charge. We in this video have read other case law, other precedents from cases that support that. And I really think the reason that they're going out of the way to cite a dissenting opinion that references this principle, it's not the main dissenting argument, is because Judge Gaffey specifically relied on People v. Moore in allowing the dual charging of intentional and reckless charges to go forth to the jury. And looking at that could be a whole nother video. Let me know if you'd be interested in it. But I do think that footnote there, referencing People v. Moore, which, yeah, there's a car involved, but the precedent that we're citing here is stuff that we've gotten from majority opinion in other case law, other cases. So I think that one was a direct call out to Judge Gaffey for his charge conference, his ruling, his reasoning. So even though I said earlier, dissenting opinion is something that you might reference when there isn't, precedent established elsewhere. Well, the things that they're getting at are established in plenty of other cases, but I think they're saying, hey, judge, even in the thing that you're referencing for your ruling that you did during the charging conference, there's issues there. That just explains that footnote when there's plenty of other cases they could have brought up. The last one that I think is of interest is People v. Butts. Maybe it's Boots. I don't know. We're going to say Butts. So Butts is well established, and Butts is well referenced in many other cases. It's cited in plenty of other cases. And the reason I wanted to include this is because of this right here. It is established New York case law that a defendant's entitlement to a charge on a claimed defense is not defeated solely by reason of its inconsistency with some other defense raised, or even with the defendant's outright denial that he was involved in the crime. So we see these same things. We have People v. Padgett, People v. Steele. And in this case, the appeals court here goes on to say, we perceive no reason why this general rule should not also apply to the affirmative defense of entrapment. And they go on here to emphasize the rule is that the jury must be instructed on all claimed defenses which are supported by a reasonable view of the evidence, not by any view of the evidence, however artificial or irrational. And I wanted to include this because the prosecution in this case says the injuries happened here, in this car, in car 1 and in the doorway getting out of car 1. But the defense argued during trial that, hey, these injuries weren't present right after car 1. They didn't appear until later. So the defendant could have had nothing to do with these injuries at all. It might not have even happened while he was present, let alone that it could have happened because of Grace Jabari's own aggression, right? So there's multiple opportunities for the defense to say that Jonathan Majors didn't cause the injuries, even if he doesn't come out and say flat out, I caused the injuries, but they were in self-defense. So there's all these possibilities and realms of doubt, right? And you're supposed to look at this in the most favorable way to the defendant in deciding whether or not you should give this justification charge as part of jury instructions. So the reason I think People v. Butts is so important is because they're saying explicitly, it's established New York case law that a defendant's entitlement to a charge, a justification charge, on a claimed defense is not defeated solely by reason of its inconsistency with some other defense raised, or even with the defendant's outright denial that he was involved in the crime. And again, we didn't have Jonathan Majors testify, but we do have witnesses saying he wasn't the aggressor. We do have evidence that the injuries didn't appear in a way that was consistent with the prosecution's claim of when and how they occurred. And we also have testimony from a different part of the night where Grace Jabari herself testifies that she struck Jonathan Majors with her right hand, which ends up being the one that's injured, during the second part of the car part 2. So even though Jonathan Majors doesn't testify and he doesn't get up there and say, hey, I wasn't involved at all tonight, the defense presented multiple possibilities that a jury could have inferred, hey, well, this incident could have happened at that point, or maybe it did happen when Jonathan Majors was in the car with her in car part 1. And it's problematic that the jury wasn't given a justification instruction, no matter what the defense was arguing when. And again, there are still other arguments being made in this motion to set aside the verdict. We'll likely see more arguments made on appeal because there's a broader scope of grounds that can be raised on appeal than in a motion to set aside a verdict. As we round this out, it's worth a reminder here that yes, for this reason, by failing to instruct the jury on justification, the court, Jonathan Majors trial court, improperly transformed the reckless assault charge, which the defense still contends the jury never should have considered to begin with, into a strict liability event, improperly rendering the context of the allegation immaterial. This constitutes reversible error under the governing precedents, including those set out above, so we went through some of the precedents about the justification charge. But I think it's worth underscoring the defense is saying, hey, you should have read this justification charge for all the charges. But we still are also raising an additional ground that the reckless charge never should have even been given, because there's nothing in testimony asserted by the prosecution or the prosecution's witness declaring that what Jonathan Majors allegedly did to Grace Jabbari on that night was born out of an act of recklessness. So if you didn't see our live stream, we had a lot of chat going on. We go over all of that there. But just remember, just because I'm focusing on case law relating to the charging of the justification charge, that this should have been given in jury instructions, even if it wasn't an affirmative defense, even if the defense didn't request this jury charge, the court still erred in not giving the jury an instruction that said, hey, if you think he was justified, if you think Jonathan Majors, the defendant here, was justified, because a person may use physical force other than deadly physical force upon another person when and to the extent that he or she reasonably believes such to be necessary to prevent or terminate what he or she reasonably believes to be the commission or attempted commission by such other person of larceny or of criminal mischief with respect to property other than premises. If you believe that this is reasonable, that whatever the prosecution's alleging, an injury occurred, even if you think Jonathan Majors is to blame and is the cause of those injuries, if he did so as a result of a reasonable belief to terminate what he or she reasonably believed was personal larceny or criminal mischief being conducted against himself, and then he was justified, and you must find him not guilty. The court was supposed to give this instruction. They did not. So, on one hand, we're arguing that the charge of the reckless charges should have even been given at all, because there's no evidence on the record where any witness is alleging that Jonathan Majors recklessly or inadvertently or unintentionally caused harm, because all of Grace Jabbari's testimony is, I knew he was trying to make me feel pain, all things that imply intention. So the charge shouldn't have been given anyway, but you put the charge forward, they found him not guilty of intent, they only found him guilty of the reckless and the harassment charge, and those charges should have came with the justification reading, and they did not. It's a lot to wrap around. And remember, if Jonathan Majors had gotten on the stand and the trial strategy was to take an affirmative defense, yes, I caused those injuries in car part 1. I did it the way that they're saying I did it. I did it in that way at that exact moment in time. But I was justified. It was self-defense. The burden of proof would have shifted a bit. It no longer would have been the people having the burden of disproving such defense beyond reasonable doubt. It would have now become, because the defense declared by statute to be an affirmative defense, the defendant would have the burden of establishing such defense by preponderance of the evidence. So if I seem repetitious, it's to drive home certain things that I think can take one or more readings, one or more times hearing it out loud to properly piece together and digest. And again, we are not looking at an appeal argument, although these same arguments could be raised in an appeal argument. We are just looking at what grounds would be viable for a motion to set aside the verdict under Section 330.30. If you want to dive into that, we do have a video where the live chat was participating. It was really informative. Again, I'll link to that all in the description. And as far as, this post-conviction but pre-sentencing level, again, it will be Judge Gaffey looking at this motion to set aside the verdict. An appeal argument would be in front of other judges. It would be at an appeals court. So with all of that being said, let me know any and all of your thoughts. We're supposed to get decisions on the motion to set aside the verdict on April 1st, with a sentencing hearing tentatively scheduled for April 8th. So you've got plenty of time to leave your thoughts, guys. The floor is yours. Let me know what you think. I hope you enjoyed this video breakdown.